Well, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. We're going to begin our hearings for today on bills. The order is subject to change as different members go in and out, but at least we are going to begin with Senate Bill 28, and then preliminarily the rest of the order for today: Senate Bill 179, Senator Watson; Senate Bill 130, Senator Bailey; Senate Bill 118, Senator Muse; Senate Bill 65, Senator James; and Senate Bill 113, Senator Kelly. And with that, Senator Holden, you have the floor.
Thank you, Mr. Chairman. Colleagues, good to see you. For the record, William Fulton, Senator, Frederick County, District 4. So the bill I have before you today is Senate Bill 28, the Violent Firearms Offender Act. The Violent Firearms Offender Act has been introduced since 2020. Little background, and passed the Senate with bipartisan support in 2020 and 2021, but has never moved in the House. The Violent Firearms Offender Act of 24 is a reintroduction of the bill in the posture it passed the Senate in 21. The biggest part of this bill is, simply put, it repeals the unconscionable drug dealer loophole where drug dealers who use a firearm in the commission of a crime or of a felony receive special treatment and are not charged with a crime of violence when others arrested for the same offense and are not dealing drugs are charged with a more serious crime. There is currently a loophole in Maryland's crime of violence statute that exempts a person who uses a firearm in the commission of a felony from being charged with a crime of violence if they are also charged with possession of a controlled dangerous substance with the intent to distribute. So drug dealers receive lighter sentences, lighter charges than non-drug dealers when they are arrested using a firearm to commit a felony in the state of Maryland. This bill will also increase the penalties for committing crimes with an illegal firearm from 3 to 5 years and raises the maximum fine of $2,500 to $10,000. It creates penalties for someone who sells a handgun or a gun knowing that they will use it to commit a crime. And the bill also requires the Commissioner of the Correctional Services to provide an inmate before release from a state correctional facility with a reentry kit for success. This includes toiletries and clothing, an ID card, contact information for entities specializing in providing wraparound services, housing, substance use or disorder treatment, and mental health services. Contact information for MHBE if the inmate is not eligible for Medicaid benefits. And if the inmate is eligible for Medicaid benefits, the commissioner must provide assistance in obtaining Medicaid benefits prior to them leaving. Public transportation information and so on. So there's another bill you're going to hear today that is in the exact same posture as this one. It's SB 179. The difference between this bill and what SB 179 is, they are identical, except that SB 28, the bill before you today, includes language that prohibits and makes it a crime to knowingly have actual knowledge of transferring or selling a firearm, a regulated firearm, to a dealer or a person that may commit a crime, cause harm to the purchaser, the leasee, transferee, or recipient of another person, and a person who violates subsection is guilty of a felony on the conviction and imprisonment not exceeding 10 years by transferring said weapon to commit that crime. With that, I'm open to questions, and I would ask for a favorable report on SB 28.
Wonderful. I don't think the committee is incurious. We've voted for and supported this bill in the past, so perhaps that's why there are no questions here. So thank you, Senator Folden. That ends the hearing for Senate Bill 28.
Senator Muse, are you ready?
Yes.
No. None of my witnesses are here, but okay. Oh wait, these is here. We can do it, right? Yes. Yep.
Oh, wow. Well, I appreciate that flexibility. So thank you to Senator Kelly and Ms. Jordan for going a little out of order here. Senate Bill 113 is next. We appreciate everyone's ability to work efficiently here today.
Perfect. Wonderful. Thank you, members of the committee. Senator Ariana Kelly here to introduce SB 113. I do not have my large font talking points, so forgive me if I stumble a little, but I'm happy to go out of order so that we can keep moving for the day. So this bill is jarring, and I'm going to try and not be explicit, but I do encourage you to read some of the written testimony. It's on the topic of child pornography, and particularly soliciting child pornography from a minor. So I was just going through in my binder testimony that is written that was submitted by Detective Kayla Staub from Frederick County. There's also testimony from Calvert County explaining some of the things that have been happening, and it's pretty graphic. So I will save the committee the graphic language, but what we're talking about with this legislation is making sure that we can enforce criminal charges against people who are luring our children in and attempting to have them send pornographic images. I had this conversation with Senator Charles today. One of the examples in the testimony just floored me. Basically, what is happening in Maryland right now is if someone is in communication with your minor child online, and this is in the testimony from Calvert County, and you as a parent, the parent in Calvert County specifically notified the police. They said, there's someone in communication with my child, and I think they're trying to solicit pornographic images from them. An undercover police officer then continued the conversation with the predator. And there was a request for pornographic images. So it's clear there was a predator out there. They were in communication with a minor attempting to get graphic pornographic images from this minor. But because the undercover police officer was an undercover police officer and not the minor, they couldn't actually be charged under solicitation of a minor through child pornography. So this is the problem we're trying to solve with this legislation. When you read the bill, which is a short bill, it just has a lot of numbers in it and sections of code. So I'm going to try and walk you through how we're trying to solve this loophole. And if you have any specific questions, I will answer them, because when you read the bill, oh, look at that, my large font. When you read the bill, it just looks like we're adding in a cross-reference to an existing statute, which is what we're doing. Just so you guys are clear, we're talking about section 207 of the indecency title, which is the child pornography statute. Again, it already exists and already makes it illegal to solicit a minor to engage in production of obscene material. So it's already a crime, already has penalties. We're not changing the penalties. I think everyone in this room agrees that's good. It's a good law. However, section 3324, which is a statute that also exists and defines sexual solicitation of a minor. So what we're trying to do is we're trying to add the crime that is in 11207 into section 3324, sexual solicitation of a minor. That's all the bill does. So it's a small change in statute. It's going to protect our children. I don't know who we have from our panel here today. I think Joyce is not here, but Lisa is. So Lisa will try and fill in everything that she can. Joyce King will be available to answer any specific questions. And I think there's some testimony from the Frederick County Sheriff's Office that can also answer more specific questions about these undercover operations that have been happening. They are intended to protect our children. We're not increasing any penalties with this crime. We're just adding the cross-reference so that we can close the loophole, so that our police officers can do the good work of enforcing the laws that we have already passed and making sure that predators are, that our children are not vulnerable to predators. So with that, I will pass it off to Lisa Jordan, who will give you painful and graphic details of why this is incredibly important. Oh, and just want to thank Senator James for co-sponsoring this bill. I have an amendment already to add her name to the bill.
Wonderful. Thank you, Senator Kelly. Thank you, Senator James. Good afternoon, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. It's my first JPR hearing this year. Happy New Year, everyone. We represent the rape crisis centers, sexual assault survivors, and others across the state of Maryland devoted to ending sexual assault. We're here in strong support of Senate Bill 113, which Senator Kelly did a really wonderful job explaining. I think there are kind of three things that I would like to say. One is that it's important when we're thinking about child pornography that we really understand the impact. Sometimes, there's this feeling of, oh, it's like just a piece of paper or something on the phone or a video, but these images, they follow people around forever. I mean, they are some of the most horrifying conversations I've had with people who, as adults, are scared now when they apply for a job, when they go to college, when they start dating. Who has seen this image of me when I was a child being sexually abused on tape? They're horrifying, damaging cases that really never go away because of the nature of the internet. The other unbelievably scary thing is how often this is happening now, that people are soliciting our kids for these images. So NCMEC it has a cyber line, and what happens with the cyber line is anytime there's an image on the internet that seems like it possibly will be child pornography, it trips the cyber line. And so since 2012, there has been an 8,000% increase. 8,000% increase in these cyber tips about images. 32 million tips. I mean, this is a huge problem for our kids, for us as a community. And I was at a community event, and one mom, I thought, really put it best when she said, I used to be worried about white vans, coming after my kids. And now I'm worried about cell phones and people asking for images. And Mr. Vice Chair, if you just give me 30 more seconds, I will finish up since I'm.
So we have a 2-minute limit, and if you wouldn't mind concluding your remarks, we'd be happy.
I will conclude my remarks by saying that this does not change the sexting diversion that you already put in place. It does not increase the risk of charging children with sexting. It doesn't touch that statute at all. And for those reasons, we urge a favorable report on Senate Bill 113. I believe Ms. King is on her way.
Thank you, Ms. Jordan, and thank you to our sponsor for presenting the bill. There's no opposition to the bill. Senator Fulton.
Oh, can they go first? Thanks.
In order down the list here, Senator Sidnor, then Senator West, and Fulton.
Thank you very much. Just wanted to make sure that I heard this is the senator correctly. You're saying that if a law enforcement officer essentially goes undercover and acts as a child, and the person solicits that law enforcement officer, that's not a violation of the law, and that's what this bill is attempting to.
Correct. That so the solicitation of a minor statute and the child pornography statute are separate. We want to add the child pornography language, soliciting of child pornography, into the existing solicitation of a minor statute. That solicitation of a minor statute protects the police officers' undercover investigations. So we want to make sure that the solicitation of child pornography itself goes under the existing protections for those undercover operations, so that if an undercover officer is that the activity is purely online and it's child pornography related, those operations would be protected, so we could prosecute the individuals.
And I see that the state's attorney says, "Oh,
well, why don't we give her a moment to get settled?" I wrote my law school note on legal impossibility and police officers as children in law enforcement actions. So this is interesting stuff. So Senator West.
Thank you, Mr. Chair. I'm just mystified at how this seems to have escaped us all these years. We've passed this is my 6th year on JPR. We've passed lots of child pornography bills, and I just can't imagine how in the world we'd missed this. I'm totally supportive of it, but how in the world did we not catch this up until this point?
Senator West, I'm going to avoid any comment on other things that could be missed by the General Assembly and say, it's just one of those technical things. We have child pornography, distributing, creating child pornography, that is against the law, but it just requires that actual child. And the sexual solicitation of a minor statute really talks about trying to get a child to have sex, trying to get a child to commit human trafficking. And the statute just wasn't there. And so this fixes a gap. It really is one of those loophole bills.
So I'll defer to the sponsor here. Do we want to take our next witnesses? Do we want to take questions?
What?
If you guys needed a few
I
more
think it would
minutes.
be beneficial for the committee to hear the specific testimony we have since we
Sounds
have
good.
them here. I
Let's
think it
do
would
it.
be helpful.
Good afternoon, and thank you so much for everyone's patience. We're literally sprinting here. My name is Joyce King. I'm Chief Counsel at the Frederick County State's Attorney's Office. You all have heard me testify several times before. I represent Intercept, the Interagency Child Exploitation and Persons Trafficking Task Force. We support Western Maryland. And I know Lisa Jordan probably covered a lot of the statistics about the rise in child exploitation. And to Senator West's question, why now is because investigations have changed with end-to-end encryption and platforms going to E2E. We are no longer going to receive those cyber tips. The National Center Missing Exploited Center is expecting an 87% cut in those tips. And that doesn't mean that these crimes aren't happening. It just means that law enforcement are not going to need to be proactive and undercover in these investigations. So, and I wanted to also highlight, this is not just for law enforcement being undercover, but also third-party solicitations. A lot of the cases that we see, predators are asking older siblings, neighbors, other pedophiles to produce these images. So it also covers that third-party section. So I will, if I entertain any questions, I believe that my colleagues have covered the other substance of this, but this is just such an important gap that we need to fill at this time. Thank you.
Mr. Eiler.
Good afternoon, committee, and thank you for the opportunity to speak today. This is actually my first time in Annapolis, but I just had a nice jog through the town from the parking deck. So again, my name is Jeff Eiler. I've been a police officer for 21 years. I currently serve as the Operations Division Commander for the Frederick County Sheriff's Office. And part of my duties is the oversight and support of the Internet Crimes Against Children Unit, commonly referred to as ICAC. And I'm inherently familiar with the dangers the children in our community face when using the internet every day. Our undercover investigators receive extensive training in the techniques and guidelines they must follow in their work. For example, detectives do not initiate conversation and never initiate sexualized conversation. They simply log into a chat room and wait to be contacted. And when I say wait, I mean they wait seconds before they are contacted and bombarded with requests for explicit images and sexual conversation. This is after they immediately tell offenders that they are a child, usually telling them they're the age of 13. In speaking with an undercover detective about this bill, she told me that nearly every individual she's communicated with online while posing as a 13-year-old female has solicited nude images from her. In some cases, she has promised some type of payment for sharing the nude images. Having seen these types of conversations that take place, I can tell you that they're extremely explicit, frightening, and frankly, quite disgusting. Well, what is even more frightening is that some of these individuals will agree to travel to Frederick County and have sexual contact with a 13-year-old female they believe they're speaking to. Some have even traveled from hours away. And most recently, one offender admitted to chatting with 5 children the day prior and exchanged explicit images with 2 of those children. One of our undercover detectives has submitted written testimony in support of this bill. I strongly urge each of you to read it as she details some of the statements that have been made to her while posing as a child. While the explicit nature of these statements are difficult to read, it will surely solidify the importance of this bill as law enforcement is currently unable to charge 11207 production of child pornography. Thank you.
Thank you, officer, for your testimony. Senator James.
Thank you, Mr. Chairman, and thank you, Senator Kelly. Thank you, Ms. Jordan. Thank you, law enforcement officer. I wanted to just tell you that you'll hear another bill that I have in child pornography, and I want to get confirmation, I think, from both these witnesses and Lisa Jordan, that part of my bill deals with the explosive numbers of images of child pornography, which is more accurately described as exploitation and sexual assault. We got to call it what it is. Now, what's happening is interesting because what they're addressing is also underlying my bill. Don't you agree? In just a moment, which is that just there's a clever, diabolical nature to these perpetrators. They're like con men. They're so manipulative. So what that's happening is they go online and they entice, manipulate, and exploit children, young children, to put images online and then secretly record them. And then you can profit like crazy from it. So what you're trying to, so my bill deals with the explosive nature and the need for increased penalties. You're dealing with this weirdly left out provision that will make sure we capture every which way a perpetrator manipulates and exploits a young child to put images of themselves online. Isn't that correct? All of you? Thank you so much.
Thank you, Senator James. I could not agree more. Thank you.
Absolutely correct.
Senator Folden, did you still have a question?
Oh, sorry, Mr. Chairman, I made it.
Got it. Any further questions from the committee? All right, with that, we will conclude the hearing. Thank you, Senator Kelly. That concludes the hearing for Senate Bill 113. Senator James mentioned she has a related bill. I like the logic of taking them together, but nonetheless, Senator Watson is coming from another committee, so we'll have him join us for Senate Bill 179, and his witnesses or panel are welcome to come up. Thank you for joining us, Senator Watson.
Thank you. Thank you. It's good to see everybody. And good to see Senator Charles in that chair over there. Folks, Senator Watson representing the 23rd District of the state of Maryland, here to testify in support of Senate Bill 179. As a quick summary, this bill labels as a felony instead of a misdemeanor at present the use of firearm with a magazine holding more than 10 rounds of ammunition or an assault weapon in the commission of a felony or crime of violence. This bill delays parole eligibility for prohibited persons who are caught possessing firearms. It also provides that a person caught illegally possessing a firearm is guilty of a misdemeanor and is subject to up to 5 years imprisonment for the first offense, and guilty of a felony and subject up to 10 years in jail for any subsequent offenses. It also requires that the Commissioner of Correction provide inmates with a reentry kit to ensure that once they leave those premises, they have at least a week of supplies, an ID card, contact information for services, and assistance in obtaining Medicare benefits. Now, this is the fourth time that this bill has been presented, the fourth time. So some of you, this bill is nothing new, but I have to ask the committee, are we ready now to take action? Because the state of Maryland is watching, and everything that we've done over the last several years with respect to guns and trying to hold folks accountable, it is clear that crime is continuing to rise, particularly among our juveniles and in the gun use. I had to present a bill yesterday, and Senator Kelly was there where we talked about the number of gun shootings, 346 gun shootings last year. And out of all the states that had gun shootings, the state that was number 2 was the state of Maryland. California came behind us, and we're only 15% of that population. This bill increases probation times. We've heard from our state's attorney that folks need probation time to even have access to services. We know that Brooklyn shooting in Brooklyn up in Baltimore, one of the perpetrators with a firearm had a monitoring device on his ankle. And so I actually, just out of curiosity, went back to the last time this bill was voted off the Senate floor, and I got the voting results. And if you look at the voting results of when this got off the Senate floor, back in 2022, you will see it's bipartisan. It was bipartisan. The difference in votes broke down among race, excluding the chair of this committee. It broke down upon race. Because we know that within the Black communities, these things are exacerbated more than any other place. But this is not a Black or white issue. This is an issue that recognizes our number one responsibility as elected folks is the protection and well-being of our citizens. Now, there are some who say, no, before you hold these people accountable, you're going to go back and address some historic inequities. We know what those inequities are. We know about housing bias. We know about food deserts. We know about poor performing schools. We can work on all those things, but we cannot negate the fact that we have people living in fear in our communities. And our senior citizens have come to me and said, do something. But when a large swath of us, senators, there are only 47 of us, decide not to vote on this issue, then there's 3 times that number on the other side of the house that will refuse to do so. It's up to us to set that leadership. The Senate of Maryland must lead this. And we have to stand up and say, enough is enough. We can rectify all of these things. I'm going to be before you 10 times this session with a variety of bills that I had the privilege to work with in a nonpartisan manner all summer long. We held a forum, a crime forum at Bowie State University where over 200 people came to show up. And I laid this bill among 12 others in front of them. And they looked at them, they tweaked them. This is too much, this is not enough, do this, do that. And so what I'm presenting is a bill from my community. This is not Ron Watson's bill. This is a bill from my community because we've said collectively something needs to be done. As I said, this bill has been presented before. There's nothing new to the bill other than the sponsor. That's me. And I'm asking for your support in getting this bill passed because we need it. It makes a statement. And the thing that was most disturbing to me, I had an opportunity to go and talk to a recently released person. And I said, you live in Virginia. Why'd you come to Maryland? The response was, oh, they don't play in Virginia. Crime will always find the path of least resistance. You all need to understand that. We need to let the state understand that. And if you have Pennsylvania changing their laws, you got DC changing their laws, and we don't act, the crime is coming here. And so I'm going to ask each of you to vote favorably for Senate Bill 179. Thank you, Mr. Vice Chair.
Thank you, Senator Watson. Senator Folden has a question.
Senator Watson, welcome. I love your bill. We have a bill in the exact same posture. Your bill and my bill, SB 28. The only difference between the two of them is that SB 28, the bill that I introduced, goes on to include that if you actually have knowledge and sell or transfer a firearm to someone that commits a crime, that there is punishment for that as well. Would you be in favor of supporting that? Or like, I'm just curious where we are, because that's the only, our bills are lockstep, 100% the same, except for that addition.
I'll tell you, Senator, that was in the original bill. And when talking to some of the attorneys, how hard it is to prove for somebody selling a firearm what the intent of the purchaser will be, which is why I excluded it.
It's very difficult, but it's not impossible. And that's why I wanted to keep it in there, because it's important. Because what people do a lot of nowadays is they communicate via text, they do via other online services and the like. So that's why I thought it was important to leave it in there, because if there's ever been a time that it's more, the opportunity exists to prove that there was the intent, it's now with the environment we live in with the electronic devices.
I agree with you.
I appreciate your
And if that's the
bill.
will of this body, I'm certainly amenable to that, but we have to do something.
Yeah, I agree.
And standing
1000%.
still is not an option.
I hear your pleas and I hear the same ones when I'm in Baltimore as well as in Western Maryland. So thank you for the great bill.
Thank you, Senator.
Just a quick addition to your testimony, Senator Watson. The other day, right on the border of my district and the chairman's district, there was a shootout, a Wild West shootout between two groups of 2 people. All 4 had weapons and all 4 fired their weapons. All 4 were also arrested, fortunately, because of the good work of Montgomery County Police Department. It was a gun deal gone bad. between the two groups. The two people who were selling the guns were from Virginia. They had no connection to Silver Spring where they were arrested, none whatsoever. The two people buying the guns were also from Virginia. They had no connection to Silver Spring whatsoever. They decided to do this gun deal in Silver Spring, even though no one had any connection to that particular area. And they had to have done so for a reason. So I appreciate your testimony.
I heard that you were a witness to that. And the last thing, let me say, when it comes to technical violations, and I've tried my best to get up to speed on what a technical violation is when someone's on probation or parole, they're effectively slaps on the wrist. But if someone's on parole or probation and they get caught with a firearm, that's a technical violation. This bill removes firearm possession as a technical violation. If you are on probation or parole and you miss a meeting, that's vastly different than having a firearm, on your person. And so this bill seeks to strengthen that as well. Thank you, Mr. Chair.
Thank you, Senator Watson. That concludes the hearing for Senate Bill 179. We'll now move back to the topic we were on before, Senator James, if that's okay with you, and we'll take Senate Bill 65.
Mr. Chair, Vice Chairman, is it okay if I'm just joining with the witnesses now that they can sit up next to me, please? Is that all right? All right, thank you very much.
I apologize, Senator James, can you give us 1 second? Is Gregory Brown here? Oh, Mr. Brown, do you want to testify in opposition to the previous bill?
Sure, yeah.
I apologize. I was moving quickly. Please come on up in opposition to Senate Bill 179.
Sorry about that.
No, don't worry about it. It's our fault.
Good afternoon to the committee. My name is Gregory Brown, Policy Counsel at the ACLU of Maryland. And our position at the ACLU is we are opposed to this bill for a few reasons. The most concerning reason is that no public safety benefits. We have rarely seen public safety benefits to increase sentences. As the Justice Center from the Council of State Governments has presented to the committee this week, it is a certainty of punishment that deters crime, not the severity of the punishment. More specifically, when we're talking about technical versus non-technical violations for parole, probation, or mandatory supervision, a lot of the people that are on parole, on probation, or under supervision are returning to the areas that they came from, which a lot of the time can be high crime areas. And the reason that we believe that this should not be a non-technical violation is because these people may be carrying firearms, simply possessing the firearms for self-defense or the nature of the businesses that they work at. A lot of people coming home from prison and jail have to work in cash businesses. Yes, those that are legal and some that may be illegal, but they're trying to provide for their families and their communities in the only ways that they know how. We know that there are crime problems in the state. However, we believe that the majority of the resources need to go to violence interruption as well as community supports so that we are not incarcerating people or that we are not bloating the system by incarcerating people for non-technical violations. And with that, I'll leave it to the committee. Thank you.
Thank you so much, Senator Folden.
Thank you, Mr. Chairman. Thank you for your testimony. Thanks for coming out today. So I'm really confused on your testimony. You're talking about certainty of punishment versus severity. I think that's an excellent point.
Yes.
This bill absolutely creates that there's certainty of punishment, not it does have an escalator for possession by a prohibited person in the commission of a felonious act.
Correct. Yes, sir.
I don't know that that's a problem, but the certainty is in there by taking it away as a technical violation. And what your testimony is that you think that someone that is a prohibited person by law because they have previous felonious charges should be able to carry illegally in the community for their own protection.
Well, yes, what I'm saying is that we cannot infer criminal intent by mere possession of a firearm.
By a prohibited person, we can certainly say that there's a criminal act occurring.
Well, yes, there's a criminal act simply because they are a former incarcerated person. However, we cannot say that someone simply carrying a firearm is trying to commit a crime of violence.
Do you? I'm absolutely baffled by where you think that's an actual reasonable statement, and that someone that is a prohibited person that had maybe already been involved and
Right.
arrested for a gun violation is now released, because Maryland loves to release people with very little time served,
Right.
and then go and secure another firearm, and then that would be a technical violation, and you're okay with that. Have you gone and talked to these mothers that are burying their children around the state?
Sir, my best friend, since I was 12 years old, died from gun violence. So I very much have talked to families. I very much have talked to people.
And in that incident, who was the perpetrator?
I'm sorry?
In that incident, was the perpetrator of your friend, and I'm sorry to hear that.
Yes.
I don't like hearing that for anybody. In
Yes.
that incident, was that person a legal gun possessor that killed your friend?
Was a legal gun possessor?
Was he legally allowed to carry that gun that he killed your friend with?
No, he was not allowed to carry
This
that
is
gun.
my point.
Right, but what I am saying is we cannot impute criminal intent onto somebody simply carrying a firearm. I am not saying that that person is outside of the law. They're operating outside of the law. Okay, they are not within the confines of legally owning a gun. But what I am saying is I cannot infer criminal intent on them if that person is carrying for self-defense.
But the certainty of punishment by carrying that weapon is important. In
Yes.
Violation.
I agree, sir.
Okay.
Yes,
thank
sir.
you. Thank you very much.
Very welcome.
Thank you. I am similarly baffled by this logic. Yesterday, we had incredible testimony here about people who were killed by drunk drivers, people well above the legal limit. None of those people entered those vehicles with the intent to kill people, but they entered the vehicle at 0.15, and it is illegal to do so, whether they had criminal intent to get in that vehicle or not. And so
Yes, I would caution against comparing drunk driving versus possessing a firearm, because drunk driving, you are not in control of your bodily function. However, you are in control of your bodily function, possessing something that has to be fired, like Senator Fulton has said several times. That is why we're here debating, sir.
Okay.
good stuff. All right. Thank you for this conversation. Appreciate you. That now actually completes the hearing on Senate Bill 179. Back to you, Senator James.
You know what I can see and what I can't see these days. Oh, hello, Mr. Chairman. For the record, Senator Mary Delaney James, proudly representing Harford County. Very nice to have the chairman join us, the vice chairman and all the members. I just want to say at the outset that I am so honored and proud to have two state's attorneys with me, and I think a third one is behind me. Joyce King, who I think everybody knows, Gavin Petushnik, and Monica Myers. Now, what I want to tell you about my bill and Senator Kelly's, and I think I and she, or both of us collectively, that rhymed. We are carrying about three bills, I think, that are really coming from the considerable opinion and prioritization of these extraordinary state's attorneys that work in the special victims unit. Okay, I got to just tell you one thing about them, which is, I can speak particularly to Gavin here. You know, for years and years, he prosecutes child pornography. That almost sounds antiseptic, doesn't it? Child pornography. Better, as we talked about, better to call it abuse, exploitation, brutalization, criminal, the most disgusting sort. But what he has to carry that is invisible to you all is he has to look at these images, not once, not twice, 10, 20, 30 times throughout a year or two of his life dedicated to trying to prosecute these people. So when he comes to us and says, look, my hands are tied, I am handicapped, I'm drowning here, please give me, this is a tiny bill when I finish explaining to you, a tiny bill, it really is. It's a tiny step, but they're asking for the help I think we should go further. I hope we do more bills together. I hope we collaborate, but this bill is important to the people who are trying to protect our children. So with that little comment, let me just say, over the past 15 years, there have been three major trends that have kind of coalesced and converged that really make the passage of SB 65 and and Senator Kelly's bill also really work in tandem in some ways. First, the victims of child pornography are getting younger, and I mean much younger, prepubescents, toddlers, yes, and infants, okay? Second, because of how young these victims are, the hideous acts against them, they're all violent, brutally violent. Just think of the size of these children. It's brutally violent, no matter what has happened. Third, advances in technology, and don't we all love technology? It gives us so much reach, so much access. Yeah, and you know what? It gives reach and access to criminals and perpetrators of these heinous crimes. Not only that, the storage capacity, right? You just have a photo album, you know, you carry a few pictures in your wallet. Now, you know, you carry a mobile device, iPad, hundreds of thousands of images. Not only can they be stored, they can be distributed, and they can be distributed worldwide. And by the way, I just learned that most child pornography, particularly this, well, it's all horrible, but there's some really extraordinarily heinous stuff. I mean, they're snuff films, people, they really are, for infants and toddlers. They come out of Europe, Asia, and places like that. But just like with drugs, and probably just like with guns, who's the biggest consumer? The United States, right? I'm going to say this out of order. I just read a report of the 182 Interpol countries. Over 50% of them have not a single law outlawing child pornography. Many have totally inadequate laws. There's only 5 countries in the world. We are one of them. Good for us. We're one of them that has what we would call adequate laws. They didn't say great laws, didn't say superior laws. They said adequate laws. 5 countries. So you understand the magnitude of this is a risk-free criminal enterprise relative to smuggling guns and smuggling weapons and things like that. Now, this bill does 3 things. And these prosecutors are going to do a much better job than I am, but it does increase the penalty for 100 images or more, right? You know, I'm talking about hundreds and thousands of pictures. It increases the penalty for child pornography for a child victim who's under the age of 13, so 12 and down, and treats each video because, you know, come on, moving images, all of us are moving toward moving images, but treats a moving image, a video, a film as 20 images, which has to deal with the penalty phase. There's a constant negative trend that's happening in this world. It's like a tipping point. What I said to Mr. Batushnik, it's a social contagion. What's his name? Malcolm Gladwell wrote about The Tipping Point. It's a great famous book. He was doing the positive side, but there's a social contagion. You can't unsee this stuff. And when somebody gets an appetite for it, and suddenly they've done probably the most perverted thing imaginable. This is out of your comprehension, I think, unless I or Gavin or someone else describe this for you. I know you were struggling yourself, Senator Kelly, as to how much to tell the committee. But once this becomes into the mindset of people, then there's a demand. Oh, that was the most filthy, brutal thing I've ever seen. Can you do one better? So now we're getting this escalation, and it's not just the United States, it's worldwide, and the perversion level of human beings is absolutely shocking. I'm going to stop because I think I've talked too long, but I do want to just go, well, I want to make a point, Senator Folden, and I think it's important, you know. Senator Kelly already alluded to it, and so did I, which is just the enormous escalation of this. And a lot of that escalation is absolutely driven by this new talented group of the most despicable people you can imagine who know how to con kids into doing things that are very, very dreadful to themselves. So it's just too much for prosecutors if we do not give them a lot more of these tools. And one last point. we need this desperately to assist in elevating the guidelines and the point system for sentencing, okay? We have made no statement in this area. We have certainly talked about other areas. We're trying to be helpful in sexual exploitation, child prostitution, all of that. But we've done nothing in this area, which rightfully is just like all these other things, exploitation, criminal exploitation, brutality of children. So thank you all very much for listening to me. And I think we're going to wait on questions probably. Okay, thank you very much.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. My name is Gavin Potashnik. Currently, I'm the chief of the Special Victims Unit of Cecil County. I'm not just the juvenile guy. My career has kind of taken two paths. One has been juvenile, the other one has been Special Victims Unit. So of the many, many, many depressing things about my job, the most depressing is Senator James is right, and I thank her for her leadership on this bill, is that we view the child pornography because there's legal requirements as to whether or not it does in fact qualify as child pornography. And she's right. Once you see this stuff, you can't unsee it. Child pornography takes many different forms, has many different types of victims, and it runs the gambit in terms of the offenders. There are some offenders which just, quite frankly, have maybe one or two images. We call them kind of tourists or people who are curious. There are people who have fetishes about collecting large volumes of what they call weird stuff. That's a different type. And then there are full-on pedophiles who have images that take, there are thousands and thousands and thousands and thousands and thousands of images. In the past, in the early time of my career when I was working in Baltimore City, a lot of times the federal government would take those cases where you had hundreds or you had thousands of images. They don't do that anymore. Their threshold is much higher. So what we're left with is a class of offenders who have many, many, many images, and we're limited to trying to prosecute per image. And the statute says that per image includes a video, and a video, some of them are 30 seconds long and some of them are 2 hours long. And believe me, you don't want to watch a 2 hour long video of child pornography. It's terrible. So why are we then treating them all as equal? This bill provides us with the tools to prosecute the offenders and provide the time to hold that classification of the collector accountable. And it also punishes those who have the images of the worst type, where you have prepubescent children, which the state would ask for your favorable report on this. I think it's necessary to hold people accountable for what happens now. Thank you.
Good afternoon. Again, Joyce King on behalf of the Maryland States Attorneys Association. I'm not going to give my introductions, but again, a big part of my job is I sit on the advisory council for the National Center of Missing Exploited Children. I brought here a binder of data and research from NCMEC talking about really the disparity and the differences in these types of offenders versus what Mr. Potashnik was talking about, a tourist offender. This bill in distinguishing large amounts as well as distinguishing the minor ages and infant and toddler content is just so extremely important. The offenders that have these types of child pornography are more likely to be collecting, distributing, chatting, and inducing the production of these images. I have data points that show that the collection of infant, toddler, prepubescent images are indicative of that they are on a more subversive level of trading and exchanging. And most likely those are images being produced and being induced by a relational relationship to the child. And the other thing that I don't want lost on this committee is that these are real victims. Why are we treating a person who's victimizing one child the same as a person who's victimizing over 100 children at a given time? So I believe that those are also important things. The other thing I wanted to highlight in my testimonies, I went before the Sentencing Commission in 2001 to raise this issue and tried to avoid the legislature and address this with the commission and address that we did not have appropriate tools for enhancements. And I included, I believe Senator James included that as a part of your packages is their report. And I encourage you all to read it because they really dissect and analyze how these individuals are charged, the limitations of our guidelines, and how their hands were really tied. And they did what they could with including victim impact categories, but the rest is up to you all. So we would ask for a favorable report.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault here in support of Senate Bill 65, commenting only on the new part of the bill. And that last year, Senator James proposed that age 5 be the demarcation line. This year is age 13. The Maryland Coalition Against Sexual Assault very much appreciates this new part of the bill. Senator West, I recall you and I also had a conversation last year during the hearing saying that telling a parent the pornography with an age 6-year-old or a 7-year-old was somehow not as heinous as a younger child just was not a good policy. 13 is an age that we use in other areas of the law. We use it in the tender years statute. We use it in our juvenile justice system. Some age is always going to be a little arbitrary, but the Maryland Coalition Against Sexual Assault believes this is an appropriate demarcation line. For those reasons, we support the bill in general and also the new part of Senate Bill 65.
All right, thank you very much, Ms. Jordan. Questions from the committee of Senator Fulton.
So whoever wants to come up and answer, I think it's a great bill. And I just wanted to point out the one thing that I thought, Joyce, you were going to bring up regarding, 1 versus 100 cases, but was the effects that these type of cases have on children after these images are sent out, because they don't go away and they're out there. And having dealt with some of those cases myself, I know I'm familiar with a couple where these young people are now adults and they're still a shell of who they were as a young person because they know that they were violated. Their trust was violated as well as their physical being by putting it out there. So, I mean, is it fair? I mean, does someone want to comment to the effects that you guys are seeing on these children?
So I mean, it's yes. So for the children who are identified, yes, but there are, I can't even tell you the many images where we never identify those children. And, I do the same stop closing whenever I'm doing a sentencing or I'm doing closing argument on these types of cases when somebody wants to try them, is that, these kids have names and you may not ever know their name. So I give them names. I say, that's Rachel, that's Susie, that's whatever, that's Johnny, that's whomever. And you have to humanize them. That's what the Sentencing Commission tried to put in its reasoning as to why they wanted to up the point for personal. And when you have people who are identified, those kids, they're devastated. I went to a training recently at a conference in Huntsville where we had NCMEC come out, and we had a woman whose entire life was plagued by a child pornographic image that just took the rounds, and she was identified, and she tried to become a teacher, she couldn't. It was awful. And those kids that are constantly traumatized by their little bodies being violated when they were however old they were old. But it also encompasses those individuals that child who's in, I'm a big country, Russia, who is violated. We never know that person's name. We never know who that person is. That person deserves just as much accountability as the person who is identified. So.
Additional questions from the committee? So I had a question how did you come up with the form? I think I asked this question last year, but or 2 years ago, whenever I think the first introduction was, but how did you come up with the formula for, okay, so I understand one image is one image, one picture is an image, but for a video is 20 images. Where did that come? I don't know how that works. I'm sorry.
Yeah, other states usually lead the way when it comes to that type of thing. And the way child pornographic images are distributed isn't what it is before. So if I took a movie with my phone and I sent it to you, Senator, and it's a movie of my dog walking, great, awesome. It goes under one batch file, right? The way that child pornographic images are now distributed is it's spaghettified. So they take almost like a flip book. If you take a flip book, and so each individual kind of second of film is sent as a separate kind of image. So you may have images that are just house, and then you have house, naked child, house. But if you put it together, you come up with a movie. So that's why, these individual kind of movies, it's 20 images per one movie. I'd love to be more, but many times you have states, that's kind of the line that they demark. So we're trying to be in line with other states' way that they do it.
Just real quick. Attached to my testimony and then attached to Ms. King's, she did a much more thorough job than I did. We looked around the country. You have, I think it's a 50 state analysis by her. I picked out selectively, and we are one of the lagging for how progressive we're probably the worst lagging state in this area when you look at the 50 states. So that's sort of how we came up with it. You know, there are ways of sharing that information. Thank you.
Thank you. I just pulled it up. It's very helpful. Thank you. And then part of my ignorance on this, you said it's a point, you said points, like a point system.
that's
Can you
what
explain that to us?
Yeah,
That's
I
sentencing.
can. So included in there's the sentencing guidelines report from the commission. So previously, there was no points being awarded for victim injury and the type of injury. So special victim, and then there's a separate category for injury. After their analysis and my testimony and giving them the same type of research that we're presenting to you all, they determined that this is permanent injury. And they also determined that these were, when the age appropriated, be special victim. But as you can see, included in that report is a chart, and all it did was take it from probation to 6 months to probation to 3 years.
And then if I could just add, Ms. King showed me the people, the guideline people, they look to what we've done in our statute so that we do not distinguish and extra penalize the youth, the young age, the number of images or the brutality. Then that they looked at that as a sign from us, a silence from us. So they are far more reluctant to start assessing points. You're not good. I got you, because I want to make sure I understood that. So they're looking at us. What are we going to do? Because that's going to have a ripple effect on how they assess points in sentencing. Thank you.
Thank you, Mr. Chair. As I read this bill, the thing that confused me was it appears that it's not a crime under this bill unless you possess 100 or more images. So you could possess 99 images and it's not
Go
a
ahead.
crime?
So
You have to read the beginning.
yeah, you gotta, so
You have to read the whole.
the bill dovetails with regular, I don't call it regular, but think of it as large amount child pornography, which is a separate crime versus, I don't want to call it normal, but the statute that deals with possession of a singular image. So 11207, 11208 deals with the possession of one image, which has its own penalty. This is an additional crime that deals with large amounts of the same possession.
So,
Okay,
Senate, yes, you have to
so
read
just, so a
11
single
207.
image is already a violation of law.
Yes.
This adds an additional crime for
Yes.
possession of 100 or more images.
Correct,
there's-
or under 13.
Right.
Gotcha,
So
okay.
11207, 11208, 11208.2. Those are the three
I see.
statutes you're looking
Okay,
at.
that makes sense. Thank you.
And good afternoon. Could you distinguish, again, just, I'm trying to make sure I'm understanding. 11208.221 from current law, if you already have something for things that are deemed one image?
So again, if I won't use myself because I won't say that, but if let's say you have Johnny and Johnny on his phone has one image of a child in a lascivious manner, all right, then you potentially are subject to the penalties under 11208. If Johnny has 100 images of all different types of children, then you're subject to this bill, which would be 11208.2. That's the distinction between the two. If Johnny has 5 videos, then instead of them being singular images, then you could be subject to the penalties under 11208.2. If Johnny has a singular image of a baby being violated, then you could be subject to the penalty on 11208.2 or 11208. It doesn't say you have to. You could, the prosecutor has the ability to charge one or the other or both, depending on the circumstances. It gives flexibility to the state in how it manages these types of cases
And
to accommodate the types of offenders.
And if I understood your earlier example when the chair had asked you a question, essentially, I guess under Roman 2, you're treating the videos as some sort of like an animation video. So I mean, it takes certain images to create 1 second of.
Yes.
Okay. I got you.
Right. So it's like a flip book. So, that's the way it's normally processed and distributed because it escapes certain types of distribution laws by doing it that way.
Thank you.
See no further questions from the committee. Thank you very much, Senator James. Good to see you all.
Thank you.
All right. With that, that'll end the hearing for Senate Bill 65. We'll now move on to Senator Muse with Senate Bill 118. Actually, pardon me, sorry. Before we do that, I missed a witness who's here to testify unfavorably.
Change his position
oh,
to favorable.
Oh, it's changed now to favorable. Okay. Come on up. Welcome.
Well, thank you, Mr. Chair and members of the committee. We are testifying in favor of this statute. I'm Jonathan Alexander. I'm an attorney and legislative counsel for the Maryland Family Institute in favor of Senate Bill 65. And we applaud your commitment, Senator James, to the punishment against the predators who possess and traffic in child pornography. There are improvements that can be made to this bill, and I think some of the questions that came from the senators do alert the improvements that can be made to this bill so that they are not a multiplicity of charges brought. The misinterpretation that came out of the bill also occurred in the fiscal and policy note where they harped on that section as well. And even how that note is written, you can see how there can be confusion. And so there are ways that we can amend this bill ultimately to make this bill stronger and other bills stronger, other bills that prosecute and punish ultimately to disincentivize child pornographers. As the senator mentioned, it is the worst and most heinous form of abuse and exploitation that occurs. And Maryland can be a leader if we make a unity of these statutes and provide clarity to some of those loopholes that if we can see them and expose them, certainly the individuals that are perpetrators would target those loopholes as well. Overall, I commend Maryland on its dedication to protecting its children from the predations of child pornography. There's been an increase in child pornography possession in the state and across the country, and it's partly influenced by children's access to social media and to the internet. And so it is a warning as much as it is a condemnation against the use of pornography. That increase of social media and internet has provided that. It's very important to ensure that we protect our children, that we fight for the retribution on their behalf, and that we attack and snuff out the evil of pornography that plays and preys against children. And I hope other states, as Maryland takes the lead, will follow our lead and see a continuation of the increases in penalties for these child predators. We ask that you give this bill a favorable report. Thank you.
Excellent. Thank you very much. Is anyone here, just kind of jump up on the witness list. Is anyone here left to testify on this bill? Okay. Excellent. Senator Kelly, did you have a question?
Clarifying question. Could you be a little bit more specific? It sounds like you are recommending an amendment. Did you have an amendment in mind that you were suggesting?
Yes. So there is language that I think we can use to have instead of that 208.2 be a standalone, incorporated in what's already current law, making it a unity of statute. One of the fears is that, and I think the state's attorney could probably speak to this more, if it is easier for them to prosecute based on those singular statute, but those two wordings in the statute, then that's fine. But if it does lead to confusion in a multiplicity of different charges, then I think we can make amendment to unify that. So it is clearer there. And in all respects, we ought to increase the penalties.
So we support increasing the penalties. You want to make sure there's not duplicative charges.
Yes, but provides clarity to it. And I think the state's attorney was absolutely clear in the need where the federal government has not prosecuted as aggressively as they should, Maryland being able to be armed with the ability to do so. But the confusion that was expressed is because the statute isn't written as best as it can be.
Thank you very much. I appreciate it.
Thank you, Senator Coe.
Okay, with that will conclude the hearing for Senate Bill 65. Now we move on to Senator Muse. Apologies for that. Senate Bill 118, you're up.
Thank you very much, Mr. Chairman. I think that Senator Hedelman, I thought was very.
She was here. Let me,
Yeah.
she's in the back. I'll get her.
Okay,
If you'd like
good.
to bring up the rest of your panel,
Come out.
make sure we grab her.
And be with us. She's
back
back
here,
here. And if they would, if you would, for the record, I'm C. Anthony Muse and represent Prince George's County 26th Legislative District. I know that we only have 2 or 3 persons to testify in support and in opposition of the bills that are of the bills coming from last year. I would like for, and I do have Chris Dews and Mr. Thomas Higdon from Recovery Advocacy Project to be my 2 witnesses or 2 persons today to witness. I would also want to acknowledge the letters of support that have been submitted, specifically Mr. Arthur Clunk, who our office has worked with regarding this legislation since the last session. Oh, yes, he's here with you. Okay, I want to thank you for working with us on this bill. Senate Bill 118 is a bill that this committee passed last legislative session after we did lots of work in amending it to make certain that everyone felt comfortable before we passed this bill out of this committee. The vote was 9-2. The Senate Bill 118 would expand again the eligibility of convictions that qualify for expungement to include driving under the influence or while impaired. The petition for expungement based on a PBJ under this section may not be filed earlier than 10 years. And that came out of last year as well. 10 years after this person is discharged from probation. Also, a person may petition the court to seal their court and police records relating to a shieldable offense not sooner than 5 years after they were discharged from probation before judgment. But if a person is convicted of a new crime during this time period, be clear, they are not eligible for their conviction to become shielded, and they are not eligible for shielding their conviction if they have a pending criminal proceeding. As you know, criminal records can prevent individuals from employment, housing, educational opportunities. In fact, more than 85% of employers still perform background checks on an applicant when they apply for a job. So if you have a past criminal conviction of any kind, then it just becomes more difficult for one to obtain employment and in some cases housing. Not to mention anything that occurs after an arrest is documented on an individual's criminal record and in Maryland. And this will remain publicly visible via Maryland case search until the charges and dispositions are expunged. In closing, and many of us are not the same persons we were 10 years ago. Of course, some people are, and they deserve, and with this legislation, it's not as though they are left behind, but in reality, none of us are the same persons we were 10 years ago. And we should not be limited to not having employment and housing and educational opportunities taken from us if we are really rehabilitated because of the past mistake. Again, this bill does not repeat or does not allow repeat drunk drivers to have their records expunged. And again, it can only be expunged after 10 years. And if you commit a crime during those 10 years, guess what? You're going to go even longer. And it's for this reason that I urge a favorable report on SB 118. I do have others who will testify as you go in that. Okay.
Members of the committee, Christopher Dews for the record, representing the Center for Urban Families, who specializes in workforce development, family reunification, and barrier elimination for Baltimore City fathers. We love this piece of legislation. I'm not going to talk long. As you all know, this bill did pass out of your committee and out of the Senate 2917 and out of the House 103-35, a version of this bill last year. So not much else to say except for I just want to highlight one piece. Then that's the fact that this bill really has no race, this issue. It has no color. It has no class. It has no direct creed, and it really has no motive. Some people who weren't able to testify on this issue were connected with the University of Baltimore School of Law, who are experiencing this. Was a young lady named Donna Bruce, who started her own trauma-informed care business for the sole purpose that she got herself a DUI because after her son died from being known as unresponsive in his car, she fell into a deep depression and then started drinking alcohol. After a fight with her husband, she then tried to leave, backed her car out of the driveway, ran over a gas main, and then, while still in cognizance, right, called the police to say, hey guys, there's an exposed gas main. When they showed up, they then arrested her and gave her a DUI. So since then, she was working at the Baltimore County Detention Center. She lost her position there, lost access to her driver's license, received 8 points on her license, and has not necessarily been able to recover properly. Apparently the Enoch Pratt, and this testimony is already in your files as well. Enoch Pratt Library has now hired her, and she's doing trauma-informed care work, helping mothers in Baltimore City who have also lost their sons to gun violence and other things so that they don't go in the same direction that she has. The only thing she asked me to highlight in these last 10 seconds is that you all take this bill seriously, that you urge a favorable report, and that it's a very reasonable 10 years expungement, 5 years shielded. It makes rational sense, and we thank you for the time.
Hello, the chairman, vice chairman, members of the Judicial Proceedings Committee. My name is Thomas Higdon. I live in Reisterstown in District 42, and I'm a person in recovery. And I'm here today as a volunteer with the State Organizing Committee for the Recovery Advocacy Project. We are testifying in favor of this bill. RAP is a network of people in recovery and impacted family members who advocate for policies that support recovery from substance use disorder, more popularly known as addiction. Recovery is a process of change through which an individual improves their health and wellness, live self-directed lives, and strive to reach their full potential. However, many people who have been successful in their recovery journey, often for years and even decades, have had job offers rescinded, have had rental applications denied, have had licensing applications denied because of a DUI or DWI on their record. And in fact, I am one of those people. 10 years ago, I was living under the JFX in a tent. That's how bad my addiction had gotten. And today I stand before you. You know, I'm getting married in May. I've got a good job. I've been sober. But a few years back, I actually, my life was in great shape, and I got a call from a headhunter. They asked me to apply for a job, and I applied, and the employer was like, yes, you are exactly what we want. They gave me a generous offer, which I accepted in a heartbeat. And then they ran the background check. And even before they ran it, I told them, you're going to find a DUI on that record because I'm in recovery. And it was as though the oxygen had been sucked out of the room. Now, the job that I applied for did not require driving, operating heavy equipment, or anything like that. It was a DUI, it was a criminal conviction, and so they rescinded the offer. Obviously, there has to be consequences for DUIs, but we at RAP believe that if you have been in recovery for over 10 years, you've done the work, you've gotten help, and now you deserve a second chance if you haven't reoffended in those 10 years. This is why we support the bill.
Thank you. Are there any questions from? No questions? Oh, Senator James.
Thank you. I want to thank you, Senator Hughes, and for the gentleman who just testified. I want to thank you. As we just kibitz, you know, we passed this bill last year, and I'm just gonna and I'll ask you, don't you agree at the end of this? But I have a dear friend who got I don't remember, it was DWI, DUI, early 30s, and his life and back when that happened, none of this permanent record, permanent, by the way, this is an extraordinary thing that we did to make it permanent till the day you die, no matter what else you do in life, right? But it would have destroyed everything, and he would have had none of the jobs, none of the career that person had. So I just want to thank you for bringing the bill back, and also thank you for finding people, because I think it's hard to come in and testify and give us some real life experience with what this bill means to people and how much it can harm people. So I appreciate that. I hope we get more support.
Thank you, Senator. And yes, I agree.
Yes, thank you.
And for the record, as I close, I have people in my congregation who for the last 20 or 30 years have had a record, and they are absolutely, they've rehabilitated, they're deacons, and some of them are ministers in the church, but they're still plagued with that record that they have to live with every day. I do believe that, again, that there are some persons who will never change, and I think that we capture that in our testimony. But I do believe in redemption, and I do believe that some people do change, and it is to them that I want to give this opportunity. So thank you very much. I urge a favorable report, and thank you again. I wish to.
Thank you, Mr. Chair. So this is a bill we heard last year.
Correct.
I was one of the two who voted against it last year, and I think I voted against it again on the floor. And here's why. The judiciary, I think, encapsulates my concern in their opposition. They say expungement of these kinds of offenses, DUIs, deprives judges of relevant information should there be a subsequent offense. It would be more difficult to make informed decisions, including as to the need for substance abuse treatment, without access to a defendant's history of all prior offenses. This would deprive the court of relevant information, and public safety may be put at an increased risk as a result. So your testimony is mostly about the detrimental effect on someone's ability to get a job because of this. I have a separate bill, which we're going to hear sometime soon, that provides that a landlord can only refuse to rent an apartment to a prospective tenant if the tenant is within 3 years of being released from jail. Beyond the 3 years, the landlord is not permitted to use the fact that the tenant was in jail as an excuse for failing to rent the apartment to the tenant. So I wonder whether or not you would be willing to consider changing this bill along the lines of my bill to say that when someone applies for a job, a prospective employer is not permitted to use the DUI after 10 years as a grounds for denying employment, but would nonetheless leave it on the books so the judiciary would know about it if the person is arrested for another DUI 11 years down the road.
Thank you very much for your question. And I respectfully do disagree with the judiciary on this issue. I did last year and I do now. I understand that from their perspective what they're saying. And I understand what you're now asking about your bill. I think your bill is a good bill. It's a good standalone bill. And but I think it's different than what we're trying to accomplish with this bill here. Again, I don't know the answer for judges not being, I did not, that was a case for judges not being able to find that information. That may be the case. 10 years is a long time. 10 years is a long time for rehabilitation. And if a crime is committed again, you go another 10 years. And so I just think in the posture in which it was passed out of here last year, I would still stick with that.
Thank you for your answer.
If I may, I don't know if this is on, and I'll be rather quick. I apologize.
So I asked the question again, and this time asked Mr. Dees if he would answer the question.
Oh, okay, fantastic. Yes, yes, and I'll be rather brief. Just to, yes, sir. Yes, sir. Yes, sir. Don't want to belabor the hearing. Senator West, first of all, thank you for the question. Love your line of rhetoric when it comes to your piece of legislation, in total agreement with it as well. It's an
I am
interesting
too.
piece of
That's cool.
legislation. Just want to
I think
also
you
just,
may have
just
been involved in
there's
suggesting that
there's
piece of
some
legislation.
possibilities, but we don't. Anyway, so I just wanted to highlight, Senator Muse has said it multiple times. I just want to consistently highlight this is 10 years. And this is also, which is actually out of congruence when we currently have for probations before judgment, which are roughly 3 years. So we're actually have a much longer window for this. And so I guess, and for the record, I understand where the state's attorney's office is coming from. I'm sure they're going to come up here and say exactly what was in that testimony. A lot of respect for them. It's just the acknowledgement that you could make that same case against expungement, period. Right? That the idea is that you should never be able to have it ever erased off the record for the sole purpose that, well, 25 years from now, we want to be able to look back and say, well, this person did X, Y, or Z. As we already mentioned, this affects your ability to secure housing, employment, licensing. We've talked to Republicans and Democrats about this piece of legislation. I've actually had more support behind the scenes from my Republican colleagues in the House. And so I understand the desire to have that level of information. I just think that there's got to be a line for when that should no longer count. And as you know, the misdemeanors and felonies that are eligible for expungement, misdemeanors right now are 5 years primarily, except for a few. And then felonies are 7 years and then 10 years for theft. So this is actually matched based on those pieces of legislation that passed last year. So we're just trying to balance that out. We think that this is a rational window in comparison. That's all I want to say.
Great. Thank you so much for your answer.
Yes, thank you again. I didn't mean to ask another question, but I could have sworn that last year, Senator Muse, you may remember, or you may remember, I thought we did amend the bill to sort of split the concerns where people like me support the idea that the employment, college, some other, but I think it's important for a judge to be able to look at it. Isn't that what we did last year? So when Senator West is asking for you to consider modifying the bill, just in fairness, we ended up, that is sort of what we ended up doing, right? Okay, because I just wanted to remember that. And then just to your comment, I think there is a slight difference to some of the crimes that you make analogy to about expungement. And I'm greatly sympathetic to drug and alcohol abuse disorders. But the reason we extend the time and treat this particular, whether it's a lifetime or we make it, more reasonable, is that when you have an addiction, which many of these people do, whether they know it or not, your brain chemistry has changed, your urges, your cravings, and it takes a lot of medicine, therapy, time for your brain. Your brain is very elastic, right? Frontal cortex. It can sort of go back to a baseline pre-excessive drinking. It does not happen very often in 3 years, often 5 years. Sometimes sobriety has to be longer, depending on when and how long it took you to get addiction. So I just want you to acknowledge that we treated this differently because of the biology and neuroscience of addiction and alcohol dependency. And that's why it's not always fair to analogize to other things that we expunge.
No,
Does that make sense?
100% agree with you. That's why I'm good with the time period.
All right, thanks.
Mr. Higdon, you had something to offer for the last?
Yes, I guess just 2 points. First, we managed to get a hold of the arrest records for DUIs going back to 1990. And we crunched the numbers at the Recovery Advocacy Project and found that it was less than 4% reoffended after 10 years. So it's a very small number of people are getting a DUI 11 years after their first DUI so that was just one piece of it that I wish Senator West was here to have heard that.
Is that Maryland or national data?
That was Maryland. Even the data set for Maryland going back to 1990 was very large and took a lot of work to get through.
That's incredible. Yeah. Okay, seeing no further questions from the committee, thank you, Senator Muse. Thank you to the panel. That'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel and we'll hear from Mr. Cox.
Thank you, Mr. Chair, members of the committee. I'm John Cox, Deputy State's Attorney for Baltimore County. On behalf of the Maryland State's Attorneys Association, opposed to Senate Bill 118. PBJ for DUI was carved out from the expungement statute for a reason. And that is, and I'm frankly surprised about the 4% number, that repeat drunk drivers commonly or often are committing offenses well past the 10 years. I can give you multiple examples of that happening. I just had one fairly recently where the person had 4 violations, every one of them 10 years older than the last one. But regardless, and the best example of the problem that's caused here is just a little over a year ago, 3rd grade elementary school teacher, Rossville Elementary, was driving home with his wife from their anniversary dinner date and was T-boned, if you hate to use the phrase, by an individual who was drunk, and he was killed. His wife was intubated for 6 weeks. He's still recovering from what happened there. He had a PBJ for a DUI 11 years before that. If this had been in effect, the judge would have no idea that he had that PBJ for the DUI 11 years before. Respectfully, Senator James, I don't think that this carve out happened. When I'm reading this, there's no circumstance where it's allowed to be provided to the judiciary.
We were talking about what we did last
Okay.
Not what's here. That's why I asked Senator Muse.
Okay.
Sorry.
Well, then it's not here.
It's not in here.
All
No,
right.
no,
All right.
was politely suggesting to him that if it was going to move at all, it would be that we would do what we did last year, which is make sure the judges always are able to see this.
And that's the most important thing
Right.
to the
Right.
State's Attorneys Association to have that information. Another problem with the legislation, and Senator Muse, I don't know if he's still here, with all due respect, the way that this is written creates a significant problem when you look at section E of 10-105. May I continue on that particular
Because I
point?
took some time from him.
I appreciate that, Senator. When you actually read this and apply the law, and when you put in this bill and put it through, what it would mean is that you can still, PBJ can be granted for a DUI after the 10 years, and it is not, as it was just stated, prohibited if the person has any crime in that 10 years. I'm sorry? No, the current law is 3 years. If you read 10-105.
Can be a person that's eligible for a second PBJ after 10 years. Maybe that's what I'm saying to you.
Oh, you're eligible.
So we're not
for a second
changing
PBJ.
anything about that in this bill.
No, absolutely. And that's not what I'm talking about. What I'm talking.
Oh, even because the court apparently, or the legislature recognized in the past that 10 years was an adequate time for someone.
Okay. And but when you look at this bill and you put it into 10-105, 10-105 says in subsection E that a judge has to grant the expungement if the person's eligible. It's not a discretionary thing. And then when you look at eligibility in section E, it says that you're not eligible if you've been convicted of a crime within 3 years of when you got the PBJ. And so that's a problem, because it's not, if somebody got a DUI 4 years after they got the PBJ, they got another one 5 years after, they got another one 6 years after, that person is still entitled to expungement of that PBJ. The individual I told you about who killed the elementary school teacher, if this passes, he can go in even after he's convicted of vehicular manslaughter and apply for, and a judge has to grant him a PBJ. If you're going to put this through, you have to change that section to prohibit the PBJ or the expungement if the person commits another crime within the time period that they're allowed to file for the expungement. Here, they could commit all the crimes they want more than 3 years after they get their PBJ, and they have to be given the expungement.
I don't want to belabor it. I mean, I think if we need a technical fix to the language, certainly something that we'll consider. But I mean, if the point of the bill, the spirit of the bill is that they're not eligible if they do these things, then the judge would not have to grant it because they would have done something to violate their eligibility. So I don't see where it's a problem, but if we need a technical fix, it doesn't seem like that's a difficult thing to achieve.
Well, if it's fixed, I agree. Assuming that this is what you want to do in terms of allowing the expungement for the PBJ. But right now, it's I think probably a little bit more than a technical fix, because the way you read it right now, they can commit all the crimes they want more than 3 years after they've been granted the PBJ, and they're entitled and have to be granted the expungement.
All right, seeing no further questions. Thank you very much, Mr. Cox.
Thank you.
Oh, I'm sorry. Senator James has a
Just
question.
want to make it nice to see you. By the
Thanks,
way,
Senator.
I just have to shout out, his wife is Judge Cox, also my former partner at Venable Beecher and Howard. So it's just great to see you.
The much better half of the relationship.
Oh, I don't, no, maybe so. Could you, look, I know you all are busy and you're coming down. I'm sure you're representing the body of the prosecutors, state's attorney. Could you provide, I think the whole committee, but I'm certainly asking for the language that I know you might say, look, I don't want to help you because I want to kill this bill, but better you give somebody who's very much wants to support your amendments, but also supports some changes to this law, this lifetime. Could you help me with some language that on the two issues that we've already last year, as a group agreed that we should not keep this away from judges. That's one thing. But the other issue you brought up, I'm not sure that we addressed last year. So if you don't want to do it, it's fine. I'm just asking.
No.
Just asking.
We are opposed to the bill, but honestly, the last part I'm talking about is more important to me than the bill not getting through.
Okay. So if that'd be helpful. Thank you.
Thank you.
Appreciate that. Thank you very much. All right, with that, that'll end the hearing for Senate Bill 118, and we'll move to our final bill of the day with Senator Bailey with Senate Bill 130. Welcome back.
Good afternoon. Thank you, Mr. Chair, members of the committee. This afternoon, I'm going to talk about Senate Bill 130. I'm Senator Bailey, St. Mary's County, Calvert County, District 29. Senate Bill 130 would provide for enhanced penalties for indecent exposure in cases where this act is done within the presence of a minor. I just want to remind the committee that we had this bill last year. It left here unanimous. It also left the Senate unanimous. So I just wanted to, and I will be brief. Under current law, all cases of indecent exposure are subject to a maximum penalty of 3 years in prison and $1,000 fine. This bill increases those to a maximum of 5 years in prison and a fine of up to $10,000 when the individual commits indecent exposure with period intent, with the person, when the person knows or reasonably should have known that the minor who is at least 2 years old is present, and where the victim is more than 4 years younger than the offender. This bill is narrowly written to ensure that we are only capturing those who would commit this crime with the intent to cause harm to a child. This issue came to light after an incident that occurred to a constituent whose child was the victim of indecent exposure. The existing penalties were insufficient to cause the offender to become ineligible for security clearance. At least 15 other states have enhanced penalties for indecent exposure against or within the sight of a minor. Maryland law already recognizes the importance of this issue and provides judges the option to require perpetrators to register as sexual offenders if they commit indecent exposure against a minor as a deterrent. This bill does not require any new minimum sentences and only gives the judges the direction and the discretion to apply these higher penalties to offenders. Last year, we heard you. Your committee provided the amendments, and the way this bill is written, as I said, it passed this committee and the Senate unanimously last year. I respectfully request a favorable report on Senate Bill 130. I thank you for your consideration.
All right, thank you, thank you very much, Senator. Questions from the committee? All right, seeing none, thank you very much.
Thank you.
Good to see you again. And with that, that'll conclude the hearings for the day and the hearing for Senate Bill 130. See you all tomorrow.